And can I just here share an observation? It's very curious for us in the United Kingdom to understand what is the basis for this distinction between Americans and foreigners. The fact that he happens to be a Canadian would have no difference at all in England in terms of his ability to obtain justice in relation to what has happened. And yet, apparently, within the United States, that makes a difference. I'd very much welcome an explanation, not in terms of the constitutionality of that decision, but in a globalizing world, what is the policy justification for being able to treat foreigners so very differently from nationals, particularly when they are a foreigner from an allied state?
So, Mary Ellen, you were asking about just civil litigation, or
either civil or criminal in the U.S. or abroad that you know of that are ongoing, certainly against high-ranking U.S. officials.
Okay. Maybe I'll tell you about the case versus Rumsfeld in Germany then, if you guys are interested in that.
That's still ongoing.
This is an interesting case because I'm going to take an angle that demonstrates what I was saying about international justice being a network rather than a pyramid. Okay. After the International Criminal Court statute came into force, the states that became party, who had agreed to incorporating the rules into their domestic law, became part of an international justice network that could then prosecute people from other countries for those three international crimes that I mentioned before: genocide, war crimes, crimes against humanity. So what happened was that an American non-governmental organization, the Center for Constitutional Rights, brought a case with the help of other groups against Donald Rumsfeld in Germany under the law that stemmed from the International Criminal Court statute that gave Germany jurisdiction.
Can I just add, Noah, there are 10 named defendants in that case. Rumsfeld is
right.
The first, and John Yoo is also included for legal advice.
Okay, so the question is, there's a lot of questions that could arise from this. Is this a wise approach? What should be the American response to this approach? Will the international justice system's legitimacy crumble, or will the legitimacy of the defendants crumble? There's a bunch of issues that are all coming into play here, and I would just like to, I guess, maybe I'll just put the question out there and then we'll see what the other people say.
Thank you.
Thanks. Let me start by a clarification, because Mary Ellen made reference to the Abu Ghraib abusers who are, in fact, serving time. And I'm totally for that. I actually got an email the day after that broke from the captain who was defending the leader of that, seeking advice. And I said, get the best plea bargain you can if the facts are as stated in the press. And they should have been prosecuted. I've talked to a number of people from Jim Schlesinger on down, and including one of your successors as head of the JAG School, who've told me most of the Abu Ghraib abuse was not related, had nothing to do with the abuse at Guantanamo. One person in all of those photos we saw, in the initial batch of photos, one person, with the one being confronted by a German Shepherd dog that actually bit him, and that was ordered by a colonel who was at least thrown out, if not prosecuted, was being held for intelligence purpose. So the rest of them were common criminals. The CIA, the military intelligence, didn't even want to talk to them. This was mostly a group of misfits who got in the Army, did not have adult supervision, and abused the hell out of some detainees. And sadly, those photos hit the street just as it was learned that a relatively small number of detainees were being intentionally abused, mostly in other ways, some of which were worse, not just humiliating, but actually torture. Now, there's an irony in my view here that we ought not to allow civil litigation by people who may be foreign terrorists, because my closest friend and colleague and center co-founder back in 1981, John Norton Moore, has authored an excellent book called Civil Litigation Against Terrorism, and he is actually one of the lead counsels in a major case brought on behalf of U.S. POWs who were tortured during Desert Storm that has been working its way up and down the courts, has now been denied cert. They're looking for collateral ways to get it back. Obviously there are some benefits to this. My concern is the issue of lawfare, the use by parties in a war of legal instruments as a way basically of attacking the enemy. And if I were Al-Qaeda's political advisor and I knew that I could file scores of lawsuits all over the United States against American generals and American intelligence officials and so forth, and make them to neglect their day job of fighting terrorism and come back and defend themselves and spend money, and maybe 1 in 50 times win a $3 million judgment to help buy explosives, I certainly would make use of that, and I think it's a serious risk. I think if our officials have done wrong, they ought to be punished, and if they've done wrong in a setting where they knew or should have known it was wrong. My concern is after the Attorney General says this is legal, I have a fairness problem. But the answer is we punish them. We put them in jail, we fire them, we demote them, we execute them if it reaches the point where the law so provides the option and the jury so decides the sentence. In principle, I understand the benefits of civil litigation. I've watched it happen. We have just started paying the judgments from Libya, the Lockerbie attack. As you know, after the Lockerbie, the Libyans were forced to admit their guilt, and then civil lawsuits got judgments of many millions of dollars, and those checks just went out about 10 days ago. So some good can come of this, but I see more harm coming from it. There's some great language from Justice Jackson in the Eisentrager case about allowing the enemy to use our legal system during time of war to throw us off our feet.